The corporation was never an innocent invention. From the very beginning, it was a tool, designed not just to pool capital, but more crucially, to limit risk. But early American corporations had another purpose: serving the public good. Surprisingly, the first U.S. corporations weren't factories or railroads. They were cities, schools, and charities. Even Jamestown, one of the first colonies, was born from a joint stock venture between the Virginia Company and wealthy English investors. The Jamestown Charter allowed resource extraction for export to England, essentially a business deal cloaked as a colony. There were three types of colonial charters: royal, proprietary, and joint stock, each representing different balances of private and crown control. The Founding Fathers weren't naive. Having witnessed the exploitative power of the British East India Company, they placed strict controls on corporations. Early American corporations could only pursue one specific project, were chartered for limited time periods, were confined to specific geographic areas, had strict cost and scope restrictions. There were no megacorporations, just two banks, two insurance firms, and a handful of canal and toll bridge companies. James Madison feared corporations could become unchecked powers. Thomas Jefferson went even further, calling protection from monopolies a fundamental human right. Yet, the contradictions ran deep. Madison, while president, approved the Second Bank of the United States. Pressured by financiers, he caved to economic necessity. Even our founders had corporate investments. Franklin owned stocks. Washington was involved in canal projects. Governor Morris invested in early banking. They were idealists, but also opportunists. In 1809, a Supreme Court case that would spark the long journey toward corporate personhood. Bank of the United States vs. DeVoe. When Georgia taxed the Savannah branch of the bank refused to pay. Why? Because they wanted a court fight, hoping to use federal power to override state law. The strategy worked. A young lawyer named Horace Binney argued that the rights of the bank's investors should count as the rights of the corporation itself. Chief Justice John Marshall agreed, and so did the court, 6-0. And with that, the door to corporate constitutional protections creaked open. Though the DeVoe case was later overturned, the precedent had been set. Over the next 2 centuries, courts would continue to expand corporate rights, culminating in landmark cases that granted corporations free speech, religious rights, and more. What was once a tightly controlled tool of the public good had become something else entirely. A systematic misrepresentation of the definition of people has created an artificial entity that can dictate governmental policy. From colonial charters to billion-dollar conglomerates, the corporation has morphed into a central force in American life. But was that always the plan? Today, we face the very questions our founders feared. Can private power truly serve the public good? And if not, who holds the reins? In 1868, the 14th Amendment to the U.S. Constitution was ratified, meant to free the slaves, to guarantee citizenship and equal protection under the law. But while African Americans struggled to claim those rights in the aftermath of the Civil War, another powerful force was already moving to take advantage of this new legal landscape: corporations. For the 44 years after the ratification of the 14th Amendment, the Supreme Court heard 340 cases involving the 14th Amendment. You might think those cases were about protecting freed slaves, but only 28 of them actually were. The other 312? Corporations, fighting not for freedom, but for profit. This is the story of how corporations hijacked a constitutional amendment meant for human beings and redefined what it means to be a person in America. After the Civil War, millions of African Americans were free in name, but not in practice. Jim Crow and Jane Crow laws kept them segregated, disenfranchised, and impoverished. Literacy was criminalized in many states like Virginia, where teaching a free black person to read came with a hefty fine. In contrast, corporations had lawyers, resources, and access to the courts. And they used the 14th Amendment like a sword and shield. As early as 1809, corporations were already arguing that they had rights similar to citizens. But it was after the Civil War when things really took off. They claimed that corporations were persons under the 14th Amendment. That meant equal protection. due process, the right to spend money on elections, all while workers, freed slaves, and citizens struggled for basic human dignity. By the 1830s, one corporation towered over the rest, the Second Bank of the United States. Backed by over $35 million in capital, more than triple that of its predecessor, the bank spread across 25 branches nationwide. It helped finance westward expansion, but at what cost? The displacement of Native American tribes, environmental destruction, all labeled as necessary externalities. An externality is a side effect or consequence of an industrial or commercial activity that affects other parties without being reflected in the cost of the goods or services involved. Whether it was clearing old-growth forests, building power plants near communities, or contaminating oceans and rivers, corporate profit at public expense. In 1827, the Baltimore and Ohio line had just 13 miles of rail. By 1861, 31,000 miles of rail were crisscrossing the country. With railroads came stock exchanges. By 1855, railroad stocks dominated Wall Street, trading 10 times more than any others. This legal maneuvering laid the groundwork for what we now call corporate personhood, a reality where an artificial entity enjoys most of the same constitutional rights as a natural person. Free speech, property rights, political spending, all wrapped in the language of liberty and protected by the courts. In the courtroom, in Congress, and on Wall Street, the line between human and corporation continues to blur. But the truth remains. Corporations may have the power of people, but they are not people. It's time to restore the Constitution to its original intent. In the wake of the Civil War, America entered a period of Reconstruction, with new constitutional amendments meant to protect newly freed slaves. But beneath the noble ink of the 14th Amendment, another power was quietly maneuvering. This is the story of how railroads, led by tycoons like Leland Stanford, hijacked the 14th Amendment, not to protect people, but to protect corporations. It began in 1882 with San Mateo County versus Southern Pacific Railroad. On the surface, a simple tax dispute. But beneath, a legal experiment in corporate self-defense. Southern Pacific Railroad, led by Leland Stanford, yes, the same man who would later found Stanford University, refused to pay taxes they disagreed with. It wasn't defiance for its own sake. It was a trap. One designed to pull the government into court, exactly where the railroads wanted them. Stanford enlisted the best legal minds, none more influential than Roscoe Conkling. A former U.S. Senator, two-time Supreme Court nominee, and, critically, a man who helped write the 14th Amendment itself. Conkling made a stunning claim. The amendment wasn't just about protecting citizens. No, according to him, the word persons was deliberately chosen to include corporations. He even brought a journal, his own, handwritten account of the amendment's drafting, to prove it. But here's the twist. That journal never mentioned corporations. There was no deliberation, no proof, no corroborating evidence, just Conkling's word. And even though Southern Pacific eventually paid the tax, the damage was done. 4 years later, the same railroad would take on Santa Clara County. Again, over taxes, but this time the real story wasn't in the arguments, it was in the reporting. Meet J.C. Bancroft Davis, former diplomat, Assistant Secretary of State, president of a railroad company, and most importantly, official court reporter for the Supreme Court. The issue at hand, whether Southern Pacific had to pay taxes on the land fenced off around its tracks. Instead of arguing that in court, Southern Pacific would again claim that it was a person under the 14th Amendment, shielded from unequal taxation. Chief Justice Morrison Waite made an offhand comment. He stated, "The court does not wish to hear argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does." A casual statement, never an official, ruling, or even argued in court. The court decided in favor of Southern Pacific on a technical property issue, not the 14th Amendment. Yet, for generations, courts would cite that headnote, a reporter's paraphrase, as proof that corporations are protected under the 14th Amendment. That's right. the foundation for corporate personhood in American law, was never a Supreme Court decision. It was a publishing decision. So how did this happen? Let's look at the players. Wait, the Chief Justice? Once a railroad attorney. Davis, the reporter? Once a railroad president. Stanford, the tycoon? One of the infamous Big Four who built the Central Pacific Railroad and lined their pockets with taxpayer subsidies. In an era of massive corruption and unregulated capitalism, the railroads didn't just lay tracks. They laid the legal foundation for a new kind of power, corporations as people. That fateful headnote, born from misdirection and ego, would snowball into decades of legal precedent. One where billion-dollar corporations claim equal rights with human citizens. One where corporate interests enjoy the protection of the 14th Amendment, while real people are often left fighting for theirs. The Constitution never said corporations were people. The court never ruled it. But in the shadows of history, a legal myth was born, and it lives on. If you've enjoyed this video, please like, subscribe, and follow. If you would like to get your own copy of Corporticians and Revolving Doors of Power, please visit Amazon Books, Barnes & Noble's online bookstore, or visit clevelandkelly.com. That's KELLY.com. Thanks for your time.